All right. Good afternoon, everyone. Boshu Anishinaabe, hello, friends. My name is Elizabeth Warner, Crock-Warner, and I have the privilege of being the dean here at the S.J. Quinney College of Law. And I want to start off by acknowledging that the land that we are on, which is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many indigenous peoples in their traditional homeland. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities such as the one that we have today. And what's really wonderful is the Salt Lake Valley has, since indigenous peoples occupied it, been a place of gathering and coming together and sharing. And so I love that we're still engaged in that activity of sharing with one another, learning from one another, with our wonderful Fordham debate to do today, which could not be a more timely topic. And I'm very excited to get to the debate. But I do want to tell you a little bit about Jefferson Fordham, whom this debate is named after. He was a vocal supporter of individual rights and racial equality. He served as dean of the University of Pennsylvania's Law School from 1952 until he reached emeritus status in 1970. From 1972 until his retirement, he was a professor here at the University of Utah. As law dean, he testified at congressional hearings and served on public panels, including one that advised President John F. Kennedy on ethics in government and the problems posed by conflict of interest. He was a strong advocate of individual rights and racial equality. He was a prime mover in 1966 when the American Bar Association created a division on individual rights and responsibilities. In Senate hearings in 1967, Dean Fordham urged a national fair housing law. It was needed, he declared, because, quote, housing, one's living situation, conditions, access to, or availability of other opportunities, notably in education and employment. He was born in North Carolina, and he received his both undergraduate and master's degree from North Carolina, and he received his law degree from Yale University. So it's really a privilege that we continue to have this, which is one of our signature events of the year and is named in his honor. Also, before I turn it over to our wonderful programs chair, Professor Cliff Roski, I do want to give a couple of thank yous. First, I want to thank our esteemed guests for taking the time. I was hearing about somebody's been all over the country traveling a lot lately, so it's really nice that they were able to take time out of their incredibly busy schedules to be here with us today. I also want to give a special thanks to Professor Ruhan Nagra, who put a lot of time and effort into this debate in particular, even though she's been on leave, and she's with us today via Zoom, so big thank you, Professor Nagra, on your work here. And then last but certainly not least, I want to thank our amazing events team. You've probably seen them around. Chris Monty played a big role in this. We've probably got Lily in the back there, I'm guessing, videotaping us. Yes, that's Lily. And many other members of our events team. These events would not be possible without them because we have large in-house, in-person delegations, but we also have about 400 people online. So managing all of that is a big effort, and so a huge thank you to our events team. So with that, I'm going to turn it over to our fabulous Professor Cliff Roski, who is chair of our programs committee, which put together today's event. Professor Roski.
Thank you, Dean Crock-Warner, and thanks to all of you for being here for the 40th annual Jefferson v. Fordham debate. We look forward to a lively discussion on a timely topic, institutional neutrality and other academic freedom controversies. And I'm pleased to introduce the moderator and the speakers for today's debate. Our moderator will be Professor Ronell Anderson-Jones, who is both a university distinguished professor and the Lee Teitelbaum Chair in Law. Professor Anderson-Jones is a former journalist and a nationally recognized First Amendment scholar who writes about freedom of the press and the role of the media in American democracy. And then on my far left, Jamil Jaffer is the inaugural director of the Knight First Amendment Institute at Columbia University, which was founded by Columbia and the Knight Foundation in 2016 to promote the freedoms of speech and the press in the digital age. He previously served in various leadership positions at the American Civil Liberties Union, ultimately overseeing the organization's work on democracy, free speech, privacy, technology, national security, and international human rights. He has argued human rights and civil liberties cases in multiple appeals courts, as well as in the United States Supreme Court, and has testified many times before the U.S. Congress. His recent writing has been published in the New York Review of Books, the New York Times, and the Guardian. And Nadine Strawson is the John Marshall Harlan II Professor of Law Emerita at New York Law School and past president of the American Civil Liberties Union. She is a senior fellow with the Foundation for Individual Rights and Education and a leading expert and commentator on constitutional law and civil liberties. The National Law Journal has named Strawson one of America's 100 most influential lawyers, and the National Coalition Against Censorship selected her for its Judy Blume Lifetime Achievement Award for free speech. She is the author of a number of important books on the First Amendment, including Hate, Why We Should Resist It with Free Speech, Not Censorship, and Free Speech, What Everyone Needs to Know. Please join me in welcoming the moderator and the speakers.
Thanks so much, Cliff, and thanks very, very much to our two guests who are joining us today. It's a real delight for me personally and professionally to have the two of them here to offer some insights at on some of the hardest issues of our time, and to help to give me the chance to help the audience take advantage of the expertise that we have at the table with all of the questions that are swirling in this space at the moment. I want to give everybody who is here a little bit of background about how this came together and ballooned into what it is. At the time that the organizing committee began planning and reached out to the three of us about our interest in participating, this was a small, discrete topic. A record number of universities had recently announced, either by adopting a new policy or by reaffirming old principles of institutional neutrality, that they would stay silent as universities on social and political controversies. And several states, including our own, Utah, had taken steps to legislatively require their public universities to adopt policies of institutional neutrality. So that was going to be the sort of tension, the grease in the wheels that we were going to focus on today. And now, just a few months later, there is a much wider array of issues in that space, a much more pressing dynamic at the crossroads of universities and political speech and neutrality. There are new headlines truly daily. In fact, the text thread that the three of us had to try to sort of keep up on what we might talk about, we finally just gave up and said, we'll talk about whatever's happening at that moment, because these headlines implicate the relationships between government and higher education and free speech and political debate and academic freedom. We have some truly rich veins to tap today with our panelists, and are doing so, as I said, at an incredibly important moment. I thought that we could come at this by moving through some of the discrete issues on which there's been debate, and then we'll try to widen the aperture to explore some of the broader tensions that are now at stake with greater urgency and the kind of fuller landscape for universities. Let's start with this notion of institutional neutrality, where I know you two have publicly taken some divergent views. On the sort of narrowest of these issues, I think there's disagreement about these institutional neutrality policies, what they signal, the use to which they're actually put. And I want to think about what are the differing views on this. Nadine, can you give us your position about the appropriateness of these, and then maybe Jamil can chime in to offer some contrasting views?
Thank you so much, Ronell, and many thanks to the Dean. Before I answer the question, I want to chime in with some thanks, particularly to Ruhan, who I looked it up, invited us on January 13th of this year. Now, when we think about how things have changed since then, bear that date in mind. But she has been absolutely a delight to work with, as has everybody else here. I also had the opportunity to interact with your longtime former dean, Hiram Hodash, in his current capacity as president of Claremont McKenna recently, and he was so excited about this debate. He said it is such a marquee event, so it's truly an honor to participate. I did research about Jefferson Fordham, and I just want to add that his enormous contributions to civil rights and civil liberties might seem rather mundane today. I think we would expect law school deans to adhere to those positions. But he was born in 1930 in North Carolina, and advocating for those positions then was really something not to be taken for granted. So that showed true courage and principle and leadership, and I'm really proud to participate. As a sign of my great respect for your school, I'm wearing your beautiful school colors. Thank you for having such nice colors. And then last thanks before I answer Renelle's question. It's the first time we've had the chance to meet in person, but I have been such a long admirer and beneficiary of your wonderful scholarship. Jamil, I met when he was almost fresh out of law school and a young ACLU lawyer and already a superstar. I am not exaggerating. Jamil, I've told you this before, you're going to have to suffer through it again. I think it was the first research memo he ever wrote for the National Legal Director, who thought it was so outstanding, he circulated it to me as the national president and the entire National Executive Committee, and it was just substantive. It was, in terms of its quality, it was outstanding. In terms of its substance, it was rather depressing, and actually ties in to the topic we are talking about today, because it really underscored the extent to which executive power has unfortunately not been reined in by the courts as much as we would like. And we were talking about George W. Bush, but we had the same problems under the Obama administration, and we were talking about a very different court. I say all of that, and some of the issues had to do with freedom of speech. I say all of that especially for the younger people in the audience. The Trump administration is causing, in some sense, unprecedented problems, but unfortunately, in some sense, not unprecedented. And if Donald Trump is no longer the president, when Donald Trump is no longer the president, I forewarn all of us, we are still going to see enormous abuses of executive power, disappointing reactions from the courts in terms of failure to enforce substantive guarantees, including of free speech. So with that historical context, I'm not sure, I don't want to disappoint you. I'm not sure Jamil and I disagree about this at all. The concept of institutional neutrality, which was most famously set out in the 1967 so-called Calvin Principles, authored by the chief author of the report that set them out, was Harry Calvin, a very revered and impactful professor of First Amendment law at the University of Chicago. But it was signed by a very distinguished committee, including the fantastic African American history professor John Hope Franklin and others, and it was setting out what had been the University of Chicago's approach ever since it was founded at the end of the 19th century. It precisely to amplify and maximize freedom of speech and intellectual freedom and robust discourse among the members of the university community, every faculty member, every student, every staff member. The conclusion was that that would be fostered if the university itself, as an institution, through its president and through other leaders, retained a policy of silence, not pronouncing with respect to controversial social, political, and cultural issues. So in other words, in order to foster free speech on the part of all individuals, the university itself should refrain from making statements. That said, there was one paragraph in the Calvin report that stipulated that if the particular public controversy directly and specifically affected the mission of the university itself, not only should university presidents and other leaders have the right to speak about those issues, moreover, the report said they had a responsibility to speak about those issues. And there are many universities have adopted variations on this general theme, and I think some of us may prefer some specific models and have problems with other specific models. But by the way, Hiram Hodash wrote a whole chapter about this recently, which he gave to me, since he's got a connection to your university. He doesn't like the term neutrality because he thinks it has connotations that he doesn't support. He prefers the term nonpartisanship, but he stresses that no matter what you call it, it really boils down to the same fundamental principle.
Jamil, I want to hear your views about the benefits and disadvantages of these, and particularly want to ask you to hone in on, it seems like Nadine has sort of set the table that different groups are conceptualizing this in different ways, and a lot may hinge on what we mean by institutional neutrality and the use to which this can be used as sort of a sword and a shield. What are the risks of certain definitions of institutional neutrality?
So let me start just by saying thanks for the invitation to speak here. It's always great to be back here. I have a kind of indirect connection to the law school here because my partner, Alice Risteroff, who's now a professor at Brooklyn Law School, used to be a professor here. But that was long before the law school moved into this building. Most of you probably have not seen the law school's old building. I don't want to denigrate that building, but I'll just say that we're all very fortunate to be in this building today. Okay, so on institutional neutrality, Nadine has sort of set out the sort of arguments for institutional neutrality, I think very effectively, and I find those arguments actually quite powerful. Just to expand slightly on what Nadine said, there are a few reasons why you might want universities as institutions to think very carefully before issuing public statements on questions that don't directly implicate their core missions. One is that institutional statements can have a chilling effect on the ability or the willingness of others to express dissenting views. Another is that drafting these statements takes resources away from other projects that might be more important. For example, establishing forums in which people with divergent views can express those views. I think there's also some danger that issuing these kinds of statements can send a message of disrespect or exclusion to some parts of the community because inevitably these statements are going to be selective. There's just no end to the political and social issues that a university might comment on. And because there's no end to the issues, there's always going to be pressure on the university to pick and choose, which issues to engage. And if you pick and choose, then you may end up sending a message of exclusion to some parts of the community. All of you know that on October 7, 2023, Hamas carried out this attack on Israel that killed hundreds of people, including hundreds of civilians. I would guess that relatively few of you know that there was an earthquake that same day in Afghanistan that killed 1,500 people and displaced 100,000. This kind of selectivity, and every university in the country issued statements about the attack on Israel. Many universities also issued statements later about Israel's military campaign in Gaza. To my knowledge, no university issued a statement about the earthquake in Afghanistan. Now, that kind of selectivity, again, I think is inevitable. But if you're a student from Afghanistan on an American university campus, you might feel like you're not fully valued as a member of the community. So all of those reasons, I think those are all good reasons for universities to think very carefully before issuing statements that don't on issues that don't directly implicate their mandates. All of that said, so I wonder how far this rule of institutional neutrality actually gets us, because I don't think there's a university out there that is really proposing to make statements on issues that, in its view, don't implicate its mandate. There's no university out there that wants to take a position on, whether Alcaraz or Sinner is the better tennis player, or who should win the election in New York City. Universities aren't proposing to take those kinds of positions. I think that most of the disagreement is about what issues directly implicate the university's core mandate. And the reason there's so much disagreement about that is that there's disagreement about what university's core mandate is. There are lots of people who take a relatively narrow view, and Harry Calvin, who was the chair of the committee that wrote the report that gave rise, at least to institutional neutrality as we think of it now, he took a narrow view of the university's purpose. He said the university's purpose is the production and dissemination of knowledge. And that may sound uncontroversial, but it turns out to be controversial. There are many thoughtful people who think universities are not just for the production and dissemination of knowledge. They're also to prepare students for participation in democratic life. That's an important part of what universities do, at least in this country. So important that it should be considered part of their core missions. And at Columbia University, I run an institute at Columbia University, so I'm especially attentive to how Columbia defines its mission. Just a few years ago, Columbia adopted what it called a fourth purpose. Beyond research, teaching, and service, Columbia University said, our university exists to bring the intellectual and other resources of the university to bear on society's most pressing problems. So there's disagreement about what universities are for, and so there's lots of disagreement, and inevitably will be lots of disagreement about when a political or social development implicates the university's mission. And for that reason, I've become increasingly skeptical that this rule of institutional neutrality, which again, I see the arguments for it, but I've become increasingly skeptical that this rule can actually help us decide when to speak and what to say. I worry that the rule actually has the effect of obfuscating the factors that universities are actually considering in deciding when to speak and what to say. I actually have more to say on this, but I've been speaking for a long time, so I'll send it back to you right now.
May I chime in?
Yeah, please do.
Because I think, as with all important principles, certainly including the First Amendment Free Speech Clause itself, which is a focus of our conversation, the terms are rather general, I think intentionally, precisely to allow the exercise of judgment and discretion, and reasonable people and institutions are going to disagree about the details. I don't see that as a problem. In fact, there has been recently, because of the increase, because of all the positive factors that would weigh in favor of some version of institutional neutrality, a lot of attention and debate and drafting that go beyond the Calvin principles or differ from the Calvin principles. One report was done by the Heterodox Academy, which expressly stresses the very important point that Jamil made, which is that different universities may have different missions. And I'm looking at the heterodox report. In point 7 says, because academic missions vary, the application of the principles of neutrality will vary across different colleges and universities. So I like that we can see the goal of what the Calvin report was and recognize that it will take some serious work and a lot of debate and discussion to implement it on particular campuses. I also want to make another point, which is prompted by something that happened very recently, which is, along with all policies, this can be misapplied and it can be cited as a pretext for doing the wrong thing. And I'm looking at November 15th, just less than a week ago, column from a researcher at Heterodox Academy talking about 2 recent incidents from the University of North Carolina system where institutional neutrality was invoked in ways that were completely contrary to the actual purpose and meaning of institutional neutrality. The first instance involved a North Carolina state had scheduled, some student group or department had scheduled a reading from an author, a Palestinian-American author, Hannah Mushabek, was scheduled to read from her children's book, Homeland, My Father Dreams of Palestine. Now, this was just a forum, sort of like the forum we have here. It was not the university president making a statement. It was not the university as an institution making a statement, and yet the university invoked its institutional neutrality policy as a pretext for canceling or semi-canceling this event. No, no, no. That was antithetical to the whole reason for institutional neutrality, which is precisely to allow individual members of the campus community to create forums, including inviting speakers, outside speakers. Secondly, from the same university system, something called I think it was called Pembroke. Quite frankly, I hadn't heard of that before, but UNC Pembroke found out through the state legislature that a Trump presidential library was going to be erected on its campus, even though it had not allocated any of its capital budget to build this library, and it hadn't been given any notice, it hadn't been consulted, let alone agreed, and because of this, fait accompli that was thrust upon it by the legislature, it would have to put aside plans that it had made for building on its campus, and it issued a statement saying, we can't criticize this because of our institutional neutrality principles. And to me, no matter how narrowly you might define something that is directly and specifically affecting your academic mission, it certainly has to include the state legislature imposing upon you a building that was completely inconsistent with your own plans. So it's a policy that can be misused as well as well used, and please don't be deterred from the benefits of the underlying principles because of inevitable misuse in particular situations.
Okay, so I think that this sort of smaller snapshot issue does really lay the table for some of the wider debates at the interrelationships between government and universities at this moment, because we see sort of all of the key terms bubbling to the surface here, right? We're hearing proponents of institutional neutrality suggesting this is an essential condition of academic freedom, that these university statements on issues of the day threaten to chill the speech of faculty and students with dissenting views, which we want to provide space for. And we hear opponents or those who are concerned about the scope of these contending that institutional neutrality can be weaponized, that it can be used to selectively punish or shut down speech, or to mask other inherently value-laden institutional decisions in ways that are problematic. And I think that if we sort of take that scope of concerns, it leads to a really great segue to some of these kinds of questions about whether universities should be neutral and what neutral means are very much at the center of some of these larger debates about how universities should respond to some of the major pivots in the current administration that I want to talk about for a minute. I want to talk about some of the big moves that we've seen this year that bear on the question of the role of universities. And just to get some of the potentially relevant developments out there, I'm going to start a little list for us. The federal government has, in relatively short order, expanded oversight related to Title VI, which bars discrimination on the basis of race, color, or national origin by those receiving federal funding. It has pushed universities to dismantle DEI initiatives. It has revoked student visas and targeted students for deportation, and otherwise tried to prevent universities from enrolling larger numbers of international students. It's talking about increased taxes on university endowments and subpoenas for student records. And most prominently, in recent weeks, we've been hearing about the fining or defunding of a number of elite universities. Billions in funds for research have been frozen. I want us to unpack a number of these trends, but first I want to ask for like the 30-second version from each of you about what, if anything, you see as the important themes that underlie this set of issues that I have just listed, right? Sort of what ties all of this together? And I want us to think about the themes from both vantage points. So what are the main themes from the government side of things? That is, why are the schools being criticized by the government? And what are the themes on the free speech and academic freedom side of things? How do these tensions that are playing out here map onto the wider landscape that we've been discussing? Let's get sort of top level themes and then see if we can burrow down. Jamil and then Nadine.
Great question. Should have started with Nadine on this one, but so let me just say one more thing about institutional neutrality before I answer this question. So I think, and this will come up over the course of the rest of the conversation, I'm sure, but I think the problem right now is not that universities are saying too much or doing too much to defend their core missions. The problem is they're doing too little. And I think that institutional neutrality, whatever merit the idea has in the abstract, and as I said, I think it does have merit in the abstract. There's no question in my mind that it's being used now, or weaponized now, if you prefer, to shut down, by the federal government, to shut down voices that are inconvenient to the federal government. It's not a coincidence that the Trump administration, in its negotiations with the universities, is pressing them to adopt institutional neutrality. The Trump administration doesn't want the universities to adopt institutional neutrality because it's interested in preserving diversity of speech on campus. It's interested in shutting down the speech of universities that would otherwise be critical of it. And in fact, that is the effect it is having, at least with some universities, which increasingly are being told by alumni or trustees or advocacy groups or others that you need to think even more carefully about issuing statements because of the rule of institutional neutrality. So I think it's important to think about not just this idea in the abstract, but how is it actually being used right now? I said I was going to say one thing about institutional neutrality, two things about institutional neutrality. The other thing is, Nadine's absolutely right that there are many versions of institutional neutrality, right? The one that Nadine and I have focused on is in some ways the narrowest version. Universities shouldn't make statements about political and social developments unless those developments directly implicate their mission. But some prominent academics and others now are urging a much broader understanding of institutional neutrality, broader in a few senses. One is not just a presumption against statements, but a categorical rule. Second is not just speech, but university conduct as well. There's a sort of movement to press universities to adopt a rule of neutrality as to their corporate activities, not just as to their statements on political issues. And then there's a question of who does the rule apply to? Does it just apply to the university president and trustees or and senior officials at the university, or does it apply all the way down to heads of departments, heads of centers and institutes? And this broader conception of institutional neutrality, this kind of amped up conception of institutional neutrality, I think is extremely dangerous. I'll focus just on one feature of it. This idea that universities can be neutral in their conduct seems incoherent to me. Universities have to make decisions about what donors they're willing to accept money from, where they want to invest their endowment, which speakers they want to honor at commencement or convocation, which schools they want to form partnerships with. Should we have a campus in Dubai? Should we have a campus in Riyadh? Should we have a campus in Tel Aviv? There's no way to make these decisions in a neutral way, right? You have to, they're inevitably political decisions. And so if you adopt a rule of institutional neutrality, you will inevitably have to go on making decisions like that. All you will have done is obfuscate that those decisions are political, and spare yourself the inconvenience of having to defend those decisions on the merits. I'll give you a very brief answer to the actual question that was asked. So I'm going to say something that's quite critical of the Trump administration, but I want you to know that before I started litigating cases against Trump, I spent 8 years after 9/11 litigating cases against the Bush administration, and then 8 years litigating cases against the Obama administration. I made lots of arguments, filed lots of cases arguing that the Obama administration was acting unconstitutionally. We tried when I was at the ACLU to apply these principles in exactly the same way to the Obama administration as we had to the Bush administration. And now I'm in a different institution. I run this institute at Columbia, but we approach it in exactly the same way. So I'm going to say something very critical, but I want you to know that I think, some credibility because I, applied these principles to the other side. I don't think that we have ever in modern American history confronted the kind of challenge, not just to the First Amendment, but to democratic values and institutions as we're confronting right now. And I think that the list that you provided, Ronell, which as you know is just a partial list even of the attacks on universities, and the attacks on universities are just part of a much broader assault on democratic institutions, including the press, law firms, cultural institutions, media, the press, I already said, but it's a broader, attack. I see this as an effort on the part of the Trump administration to consolidate authority, to silence voices that are critical of it, the same kind of pattern that we've seen in other societies that have transitioned from democracy to authoritarianism. Societies like, Hungary, India, Turkey, El Salvador. This has happened all over the world, and what's happening in the United States now is very similar to what happened in those places.
Yes, so briefly on the institutional neutrality point, even the Calvin report itself, as Jamil knows, makes an exception for conduct when the university is acting in its corporate capacity, and actually gives as examples university ownership of property, receipt of funds, its awarding of honors, its membership in other organizations. The Heterodox Academy recognizes explicitly that the particular context in which institutional neutrality is being considered will be outcome determinative, and therefore at least be a significant factor, and therefore the report from which I was reading expressly focused only on university-wide statements, declarations, and expressly said we are not yet now addressing other potential instances of institutional neutrality, including financial decisions, including whether you're talking about individual departments or centers, recognizing precisely that those call for different analysis. That said, that project was put on a back burner because after I'll use January 13th as a significant day here when all of us were invited to talk about institutional neutrality. Donald Trump took office and a lot of other issues became dramatically much more urgent. The theme that I see underlying all of the attacks that were listed by Ronell and many others, some listed by Jamil, is precisely the opposite of protecting diversity of viewpoint, which I think has really been the fig leaf justification. I don't really hear the administration talking so much about neutrality as much as they're decrying the supposed takeover of universities by so-called woke progressive leftists and paying some sort of lip service in some context to the idea of viewpoint diversity. For example, trying to impose it on Harvard University in the extortionate demand letter that it sent to Harvard, demanding that there be viewpoint diversity at every level of the university in every single department and every single course and so forth. But in fact, what's actually happening is the exact opposite. It's the imposition of another kind of orthodoxy. You can call it anti-woke orthodoxy, if you will. And for those of us who have been toiling in the free speech vineyards, it's predictable, but still always disappointing that you see this complete inconsistency, hypocrisy. So, you know, while the Biden was in power, many conservatives and Republicans, including Donald Trump and J.D. Vance, were, you know, talking about how they are free speech champions and they're going to end government censorship. And in fact, there was even an executive order on the very first day of the Trump administration ending censorship and bringing back freedom of speech. But then you look at the actual actions and they're just mirror images of violations of free speech in the prior administration. I do want to echo what Jamil said about the scope and scale of what we're facing now. And I have even more decades of involvement, and I have consistently resisted constant questions from the press. I'm sure both of you field these as well. Every time there's a new dramatic violation of free speech and all of the administrations have had some violations. Is this the worst that you've ever seen? And I always say, no, I want to remind you of what's happened in the past. But I would say, you know, we are facing an unprecedented challenge now. And let me mention one other factor that I think has not yet been mentioned expressly. In addition to crumbling of what should be checks and balances against executive overreaching, the courts are doing quite well so far. I'm superstitious, so I'm knocking wood or a wood-like surface here. Congress, of course, has been completely supine, not exercising any of its expressly delegated powers, let alone checking and balancing. But the civil society institutions that have traditionally been part of this checking and balancing, the press has expressly been referred to as the fourth branch, right, because of that historic function. And universities have served that function. It's no coincidence that they are being singled out. But the single greatest threat, if I have to choose, is the unprecedented assault on the legal profession, our profession, lawyers and law firms. And you cannot have any constitutional right, including freedom of speech or academic freedom, without judges, but also without lawyers. The Constitution, including the First Amendment, is not self-executing. For the vast majority of its history, from 1791 on, the Free Speech Clause was a dead letter. As James Madison forewarned, it was only a parchment barrier between we the people and government abuses of power. And that's why we had, at the beginning of the 20th century, the foundation of organizations like the ACLU and the NAACP to educate people about what their rights are, to encourage them to stand up for their rights, and to provide legal resources to take the cases to the courts so that the courts would have the opportunity to actually enforce those rights. And I'm speaking to all of you law students here. Really, the future of academic freedom and free speech is so much in your hands, and I hope that you will not be subject to the bullying and intimidation that we have seen on the part of even the most powerful, wealthy, prestigious law firms in this country succumbing to the extortion from this administration. We see it at the ACLU, FIRE, Jamil can speak for himself, but even organizations that have outstanding staff lawyers have always depended on law firms and lawyers in private practice because we do not have among our own staff the resources that we need to be able to keep up with the torrent of unconstitutional actions that are being taken by the administration. And so you see law firms that used to provide resources to organizations such as ours, also in the immigrants' rights area, has been very profoundly suffering. But worse yet, the resources that used to be used for pro-civil liberties and civil rights advocacy is now being allocated to the Trump administration's pet causes. And for every law firm that you know that has signed one of these extortionate agreements, there are countless others that are cowed into silence. We are seeing a severe drop-off in those that are willing to stand up even against clear violations of constitutional rights.
Okay, so I want to loop this back to ask a broader question about the impact of elections and the impact of decisions that we task our government with making. And I guess more broadly, to bring it back to the topic at hand of the question of universities and particularly university funding, because a lot of the issues that we were talking about here are simply governmental decisions about funding or governmental threats related to funding. They're tied to the dollars that come from the public purse, from the federal government to universities. And I guess the question is, why shouldn't federal agencies be free to choose which universities and which university programs to fund or not fund, right? After all, right, the government speech doctrine permits governmental officials and agencies to choose which messages they fund or don't fund. Presumably, elections are the tool by which we decide sort of how our government spends its money and how it doesn't spend its money. Can you respond to the question of whether this is the same as has been happening before, which is that government dollars are always tied to government policy, and universities, I mean, maybe the argument is that universities have gotten themselves all bound up in federal dollars in ways that were inappropriate from the beginning. But can the two of you speak to this question about whether the government speech doctrine simply permits this kind of funding control? I want to speak in more detail to the question of the settlements that are existing and the compact that has been proposed. But on a broader level, if we're thinking, we can think about governmental authority to make these sorts of decisions versus the sort of best university strategies in response to them. But on the what are your responses to the first of these points?
Yeah, I mean, I think that First Amendment doctrine draws a line here, which is sometimes hard to apply in practice. So the government is entitled to be viewpoint discriminatory in its own speech, right? The government can run a public service advertising campaign that is encouraging people to stop smoking or encouraging people to get their vaccines, say, the government, could, if it chose, run campaigns on the other side of those, of those issues. It could also fund university programs that are an extension of that government speech. So, if the government wants to create a program at this university to focus on the harms of vaping, it can dedicate funds for that purpose, assuming the university, accepts the funds, and limit the university to using those funds only for that purpose. So the government speech doctrine, gives the government that kind of power. But the courts have been very attentive to the possibility that the government might use that kind of power, not just to affect its own speech, but to leverage the funds to silence speakers outside the scope of those programs. And so that's kind of the analysis that the courts go through. They always ask, is this condition on the funding just meant to preserve the integrity of the government's speech, or is it meant to silence? And like I said, it's sometimes hard to apply that rule. I don't think that the questions before the courts now relating to the Trump administration's actions are complicated from a First Amendment standpoint. And you've seen, courts across the country now, some of them appointed by President Trump himself, hold that these kinds of conditions on federal funding are unconstitutional. But more broadly, what the Trump administration is doing is grabbing onto whatever leverage it has in the particular sphere. With universities, it's federal funding. With the media organizations, it's sometimes regulatory approvals for mergers or the FCC's authority over licenses. With foreign students, it's visas. In different spheres, the government has different levers, but in all these spheres, the government is using these levers to try to bring speech into harmony with the Trump administration's agenda. Just one more thing about. Since I'm in Utah, I assume that some of the people in this room, that there's a diversity of views in this room about the Trump administration, and that some of you are probably registered Democrats and some of you are probably registered Republicans. And I just want to urge everyone not to think about these issues through a partisan lens. If you're a conservative, the principles that we're talking about here are conservative principles. The idea that the First Amendment leaves it to individual citizens to decide for themselves which ideas are worth listening to and which ones aren't. That is a conservative principle, and that is the principle that the Trump administration is ignoring or violating in all of these contexts. When the Trump administration says to ABC, because President Trump said this just yesterday, I think, or the day before. He was asked a question that he didn't like by an ABC News reporter, and he says, your license should be revoked. That is an incursion not into some democratic principle or some liberal principle. It's an incursion into a basic democratic principle that is democratic, small d, that is at least as important to conservatives as it is to liberals in this country. And I just want to urge all of you to see this in a nonpartisan way, not through the lens of political party.
I want to second that and give a couple examples and then respond more directly to the question. So in March of this year, after we saw the first defunding salvos, in particular against Columbia, I think was the first target, and maybe Harvard was the second target. I was one of 10 signatories, 10 constitutional law experts who signed a letter complaining about the violations not only of the First Amendment, but also of the statute that was being invoked by the administration as supposedly justifying the defunding, namely Title VI of the Civil Rights Act, and also a deep violation of the Administrative Procedures Act. And we were 5 liberals and 5 conservatives. And the conservatives included Michael McConnell, who was a judge on the 10th Circuit, which of course I know Utah is in the 10th Circuit. Also Steve Calabrese, who, and Michael, a very respected conservative who had been appointed by Ronald Reagan to the court. Also Steve Calabrese, who was the founder of the Federalist Society. And what's so interesting to me is that opposition to federal government involvement in education was always the hallmark of Republicans and conservatives who long opposed the creation of the Department of Education precisely because of concerns that the federal government, by being intruded into education, number one, would undermine states' rights and states' power, because this is a prerogative of state governments, and number two, would undermine the autonomy and independence of educational institutions, private as well as public. And so when the Department of Education was finally created, there was express language that strongly said that no power of the federal government, including funding, would be used to detract from, undermine, threaten the institutional autonomy of the educational institutions. So I agree with Jamil that these principles are at least as much grounded in conservatism as classical liberalism. On the funding question, just to add one other way of thinking about it, a lot of people say to me, well, you have no right to government funds. Harvard and Columbia and even the University of Utah have no right to government funds, so what are you complaining about? And the answer is that even though you have no right in the abstract to receive government funds, there are certain impermissible grounds on which the government may deny funds or remove funds, namely if the grounds include forcing you to waive what would otherwise be a constitutional right. And think about it this way. The First Amendment, and I'll use the First Amendment as an example. The First Amendment says Congress shall make no law abridging the freedom of speech. The Supreme Court has wisely interpreted that language in a very functional, pragmatic way. That, of course, a law that said thou shalt not teach critical race theory would be explicitly unconstitutional, but any other government action that as a practical matter will have a similar deterrent or chilling or suppressive impact on speech should also be considered an abridgment of speech. So, withholding the carrot of government funding because of disapproval of ideas is functionally the same as wielding the stick of direct government prohibition.
We've been speaking primarily about interactions between universities and the federal government, but many of these dynamics, including the institutional neutrality rules that were our initial focus, are mandated by state legislatures. And I'm looking ahead to our Q&A time. I want to engage the group. But lots of the themes that I'm seeing in the Q&A are focused on state universities and the relationship between state governments and state schools. And I want to ask a set of questions that loop back to something that Nadine said earlier about how, in an ideal world, institutional neutrality would have nothing to do with restricting expression by individual members of the campus community, but instead would seek to facilitate the most robust expression by all of the members of the campus community, making sure that there were a vibrant marketplace of ideas both among the professors at a university and amongst the student body at a university. So I want to lay out a couple of sets of things that people are super interested in. One set that has to do with firings, faculty firings, and another that has to do with faculty hirings. And I want to see if the two of you can sort of chime in about how the interrelationship between academic freedom and fostering universities as vibrant places for bipartisan and transpartisan conversations are impacted by these two sets of things. The first set of things I want you to think about are tensions over the firing of university professors over ideas that they've expressed either in the classroom or on social media, and whether these implicate any of our themes here. Some examples I'm thinking of: Texas A&M gender studies professor and university president, both removed after a controversy related to discussions of gender in the classroom. There were firings and suspensions of professors who criticized or spoke distastefully about Charlie Kirk in the aftermath of his assassination. These are recent examples, but there were, of course, earlier examples across the ideological divide where public school teachers and professors were fired in the wake of George Floyd's death in 2020 for what were seen as insensitive or disparaging remarks, or teachers who were fired for refusing to use transgender students' preferred pronouns. FIRE and other groups have taken strong positions on these matters, and so I think if we're rounding out our conversation about the interrelationship between universities and speech and diversity of viewpoint, that's an important one on the kind of firing side. And then I want to give you a sort of set of facts about hiring. Some state legislatures, including Utah, appear to be significantly scaling back funding to public colleges and universities, but they're making special initiatives and funding available for hires that are ideologically specific, dollars to be used to counterbalance what they say has been a concerning left-leaning bias in higher education. And states and state universities have tried to tackle this in other ways as well, like prohibiting the sharing of personal ideological views in the classroom. So I'm wondering if the two of you can speak to this question of the kind of themes that we were seeing in in the institutional neutrality space, and how they map onto this kind of trickle-down relationship between government and universities, and how best to foster the kind of marketplace of ideas that that you were sort of stating as institutional neutrality goals in the front end. Nadine, I know you're involved in both heterodox and FIRE, and I know they both have strong views on both the firing and the hiring side. I'm happy to hear from either of you if you have.
It's your turn.
Well, I'll make just a couple of very brief points. One is, I think it's important to remember or to know that institutional neutrality, as Calvin described it, actually had multiple pieces. One piece was what we've already talked about. Refrain from making statements except under certain conditions. But another piece that was tied to the university's obligation to create an environment in which every view could be expressed, or any view could be expressed, and every idea would be scrutinized. And there has been a lot of attention to universities' purported non-compliance with the rule relating to statements, and less attention, I think, to universities' compliance or not with the other aspects of this idea of institutional neutrality. And I think that universities have not done as good a job as they should have in fostering the kind of environment that allows for every view to be expressed and scrutinized. You can see that through the firings. So many professors being fired for their for political statements that they made as ordinary citizens, or even for the subject of their academic research. And you can also see it, I think, this is a much longer conversation than we can have at today's event, but I think you can also see it in the way that universities have responded to student protests over the last 2 years, when I think over and over again, universities shut down speech on viewpoint-based grounds or applied what were on their face neutral policies in viewpoint discriminatory ways. So that's point one. And the second one is just about hiring diversity. So I actually find this a really hard question. On one hand, we all want universities to be places where there's a diversity of opinion on important social and political questions, and even within particular fields, you want you don't want some orthodoxy to take hold. You want ideas to be continually challenged, and in order for ideas to be continually challenged, you need people who disagree with each other. Nobody wants universities in which we're just indoctrinating people into one particular view. Well, I don't know if nobody, but most of us don't want that. But on the other hand, the university is different from the public sphere, right? In the public sphere, we protect free speech on the theory that every idea is entitled to equal respect, or formal respect at least. Every idea can be expressed, and that stems from the idea that each of us is an equal participant in democracy and has the same claim to ownership of sort of democratic life and space, and so the government can't discriminate on the basis of viewpoint. It can't say, we like your views, and so you can have this particular advantage, and we don't like your views, and so you can't. That's all disallowed, because in general, in the public sphere, the government isn't allowed to discriminate on the basis of viewpoint. But at the university, it's not true that every idea has equal status, right? Universities exist for the pursuit of, at least part of their mission is the pursuit of truth and knowledge. And implicit in that idea is the exclusion of bad ideas, right? So, you have at the university all sorts of processes to ensure that better ideas are elevated and bad ideas are marginalized. That's what peer review is about. That's what the tenure process is about. The whole point is to marginalize ideas that are less good. So how to reconcile that with what I started with, which is that we don't want orthodoxies to take hold. I don't actually have an answer to that question. I do know that, or I do feel confident that the answer is not a government-imposed requirement of viewpoint diversity. That seems like exactly the wrong way to go.
Okay, I want to make sure that we get to questions from the audience, but I want to make sure that you also have a chance to chime in on this before we do. I'm going to look over questions while you do this.
Okay, well, I'll just try to be very brief because it's a very complicated issue, but I'll focus on one aspect that Jamil didn't have time to discuss, and that is when faculty members are speaking not in their professional capacities as scholars or teachers, when they are subject to professional norms, peer enforced norms, as Jamil said, but when they are speaking in their capacity as citizens, as the Supreme Court says, and it doesn't mean literally, citizens in technical sense, they can be non-Americans as well, but speaking in their capacity as general members of our political social community, not subject to their professional responsibilities as scholars and teachers. And the rule that the AAUP, the American Association of University Professors, adopted at the beginning in 1915, which has now been woven to a large extent into First Amendment law, is that you do not have to forfeit your general rights of free speech as a member of a citizen of the political community as a price of retaining your position in the university. So the way that is concretized in the AAUP standards, they refer to this as extramural speech, what you're saying on the quad or in social media, should not be taken into account as a ground for punishing you in your professional capacity unless your extramural statements show that you are demonstrably unfit. And the AAUP goes on to say, and that is an extremely rare circumstance. Moreover, what you say, the particular controversial statement has to be considered against the overall record. So FIRE, as you mentioned, Ronell, FIRE is very involved in these situations. Just today, I saw a new press release where had been representing a tenured law professor at the University of Kentucky who was suspended because of controversial anti-Israel statements that he made. And FIRE represented him through the university disciplinary process. And now CARE, the Council on American Islamic Relations, along with FIRE, are challenging that suspension in the federal courts.
Okay, I'm turning to the Q&A, and Slido has a system whereby we can not only submit questions, but the audience members can read those questions and vote them upwards to say, I too would like this question answered. It's clear that the question that the audience wants answered is for you all to chime in on a controversy that is brewing here on our campus and related to our university and institutional neutrality. The University of Utah reached an academic cooperation agreement with Ariel University in occupied Palestinian territory. And the memorandum of understanding that the university entered into refers to it as being in Israel. So there is controversy on the geopolitical landscape here. And if I'm boiling down to a nutshell, the top 10 questions that have been voted to the top is seeking your response about whether that kind of dynamic is the sort of thing that you have in mind when we're thinking about institutional neutrality. Is this is this a violation of institutional neutrality for the university to take a position that gestures towards those geopolitical questions, or whether is this the sort of thing that is consistent with institutional neutrality, and how does this dynamic, how does this real-world hometown example play into the tensions that the two of you have been discussing? The people want to know. The first 15 people want to know. So
I think that this is, a partnership like this. Is it fair to call it a partnership? Is that a partnership like this?
Cooperation agreement.
A cooperation agreement like this, I think, shows why applying a rule of institutional neutrality to conduct is incoherent. The university has to decide, are we going to have a partnership with Ariel University or not? That is not a neutral decision. It can't be a neutral decision. The university has decided that we're going to have this partnership and not some other one, right? And presumably the university would draw lines, like there are partnerships that the university wouldn't enter into, and yet it entered into this one. So why did it enter into this one? Well, you might ask the university to issue a statement. I don't know whether the university would issue a statement explaining the decision on the merits. They might say, well, that's precluded by institutional neutrality. But I think that this is sort of reflects what I was trying to say earlier, which is that in this kind of context, the rule of institutional neutrality, if you apply it to corporate activities, works mainly to obfuscate decisions that can't possibly be neutral, and to spare the university from having to defend those decisions on the merits. And I will just say that even the Calvin report which, as Nadine mentioned earlier, the Calvin Report sort of accepts that universities have to act in their corporate capacities, and that decisions made in the corporate capacity can't possibly be neutral. But the Calvin Report then goes on to say there will be exceptional circumstances in which the university's corporate activities come into conflict with paramount social and political values. And in those circumstances, the university must reconsider its corporate activities. Now, there's going to be debate about what are paramount social and political values. Are the university's decisions in conflict with those values? But I think we have to have that debate on the merits, and you can't possibly pretend that those decisions are neutral.
I'm going to tack on just another piece of the question that was asked by the editors at our school newspaper, the Daily Utah Chronicle. If entering the MOU is found to be non-neutral, would leaving the MOU also be considered non-neutral?
It is non-neutral, but that doesn't make it inconsistent with the purpose and scope of institutional neutrality. I completely agree with Jamil, and I think it's really important in every such situation, including any involvement with any foreign university. And I don't know the facts here, but many other universities have exchange programs for students and for faculty members in both directions, have campuses in other countries, including expressly authoritarian countries. And this, I think that the universities must be transparent about this, must have debates that are community-wide about what are the trade-offs, what are the guardrails that are put into place to make sure that it is our concept of academic freedom and free speech and not those very different concepts of those other governments that are at play. I'm speaking now having in mind a new book that was written by one of my colleagues at FIRE called Sarah McLaughlin, and the book is called Authoritarians in the Academy. And she also has a monthly newsletter on Substack in which she goes into much less well-publicized instances than this, often involving China, often involving the Gulf states, where American students and faculty members, unbeknownst to them, have had their academic freedom and free speech rights traded away by the university as the price for entering into these partnerships. So I would say the underlying lesson here, no, these decisions are not neutral, and they're not neutral even with respect to the most fundamental freedoms. So, you know, the student newspaper can play a very important role in getting information and demanding information, in stimulating debate and discussion. First of all, we need basic information, and then second, we need discussion about the countervailing values that are at stake. What is to be gained, what is to be lost.
Can I just add one very short thing as a kind of human rights lawyer and not as a First Amendment lawyer? You know, I think these kinds of, I don't want to sort of take a position on this specific partnership, but I do think that these kinds of partnerships can have the effect of laundering terrible human rights abuses. And you know, Columbia and NYU also have campuses in places where human rights abuses are rampant. You know, for the same reasons that universities are now, I think, thinking more carefully about which donors they're willing to accept money from, I think they need to think more carefully about which partners they're willing to work with in partnerships like this.
We have several questions that I'm going to group together that live along a common theme, that are asking about the current environment of polarization and recommendations that you might have to help students and faculty build trust and create an environment where all individuals feel free to speak, and in particular to think about the ways that we can avoid the chilling of free speech within our classrooms and within our faculty-student dynamics. What advice do you have in creating those sorts of spaces?
Yeah, I mean, I think some of this is just individual behavior, or maybe the better way to say it is just sort of free speech culture, which has unfortunately eroded, over the last 20 years, I think in part because of social media. The problem one problem that social media has created is what people have called context collapse, where the only thing you know about a particular speaker is the 5-second clip that has been posted online by somebody who didn't like what that person had to say, and it is very, very tempting to to judge people on the basis of those clips, to judge them immediately and to pile on when other people have judged them. And I won't claim to be immune from that instinct myself, but I think it's a very unhealthy instinct. And we'd have a better society if collectively we tried a little harder to resist that impulse.
Throughout my long law school teaching career, even before the current crisis in polarization and chilling impact on people's expression, purely for pedagogical reasons, I had an approach that I think now also serves to increase willingness to discuss different perspectives. So my rule for all of my students was I never asked them, and I taught constitutional law, I never asked them for their own personal views or their own personal conclusions. I simply demanded that on every issue, they had to be able to understand, articulate, and advocate all plausible perspectives on all issues. And that meant they had to be able to defend those perspectives in terms of the relevant sources of authority, the constitutional language, Supreme Court precedents, logical analysis, and so forth. And that, I realize now, has the double advantage not only of forcing people to be open-minded toward perspectives other than their own, because there's no better way to understand the strong points. You might not ultimately be persuaded, but the strongest points of a view that you had rejected, than being forced not only to articulate it, but to advocate it. Great advocates like Jamil know the best way to practice your own argument is to be devil's advocate, be subject to devil's advocacy. But it had the double advantage of divorcing students from identifying with any particular perspective. They were not going to be pegged as being pro this or anti that. So at least in law school classes, I think that's a very helpful approach.
Great. Jamil, I'm going to give you the chance to answer the last question, and I was going to land softly, but I decided to land hard. So there are a set of questions here that revolve around the Charlie Kirk assassination, which is of particular interest to lots of people in this room because it happened not far from here. And we have a wide array of questions that sort of tap into that moment, some from conservative students who wished that the law school or the university would have made more official statements about the impact of it on them and on us as a community. Others who have concerns about the reactions and the free speech environment in the aftermath of it. I'm going to sum it up with one of the questions, although there are many of them. One question is asking, sorry, it has disappeared from my Slido. Maybe, okay. The gist is, what can we learn about this moment in the aftermath of that assassination about institutional neutrality and free speech on campuses?
Well, let me
2 minutes.
Yeah, let me start with what I hope doesn't even need to be said. But I mean, this is a terrible, terrible thing for our country, that people are, somebody who is engaged in the political sphere like Charlie Kirk was assassinated on that basis. There's no future for democracy in this country if people are killed for their political views. So, whatever you thought of Charlie Kirk or whatever you think of him now, I hope we can all agree that this was a really horrific thing for our country. As to what the university should have said in response, I think this raises all the questions we've already talked about. It's very, there's some people who would presumably take the position that this doesn't bear directly on the university's mandate. The university is here to produce and disseminate knowledge, not to comment on political and social events. And others who would take the view that no, the university's mandate is broader, encompasses the defense of democratic institutions, including free speech. And this was, a huge affront to free speech, and the university has a role to play in reaffirming the value of free speech and the horrific nature of this assault on it. I think I probably fall more into the latter camp than the former, but where you fall sort of turns a little bit on how you define the university's mission. I've already used up my 2 minutes, but I am very concerned about the free speech, the sort of post-Charlie Kirk assault on free speech, because I think that, obviously we need people to be able to disagree about Charlie Kirk's legacy. People need to be able to say, not just that, I thought he was a powerful speaker and very persuasive, but also I thought he was a bigot. Those things are constitutionally protected, and we want them to be permissible things to say in our society. And the right way to respond to somebody who says something like that you disagree with is just to disagree with them, and I hope not to try to get them fired from their jobs. That's a complicated thing too. We all are going to have to draw a line somewhere where we think, well, this is within the realm of permissible speech, and this is outside it. Somebody should lose their job for this. But we're all better off, I think, if that space is broad rather than narrow.
Just the day before Charlie Kirk was assassinated, FIRE released its most recent annual survey of students' attitudes conducted by College Pulse, which specializes in surveying students. It was the largest ever, 70,000 students on 257 campuses. And in the press release, the evening before the assassination, eerily, FIRE headlined as one of there were many disturbing findings, but the one that it highlighted was 34% of students said that violence is at least sometimes justified as a method for silencing a speaker you disagree with. And for the first time, students who self-identified as conservatives and Republicans equaled in percentage students who self-identified as Democrats and progressives in supporting that sobering, scary conclusion. And FIRE's press release said this is not a conservative problem, it's not a liberal problem, it's an American problem. And I think it relates to a trope about free speech that I have had to contend with constantly in my constant evangelizing on the topic. Many students say, and I fear, quite literally believe, words are violence. And again, surveys show a great deal of support for that trope. If you believe that words are violence, then it's not so shocking that you think an appropriate way to respond to words is through violence. And I think that universities should have it deeply within their mission to help students, faculty, all of us understand that far from being violence, words are the antithesis, the way that we negotiate our conflicts, our differences at the interpersonal, to the international level is appropriately through words, through dialogue, through negotiation, and never through violence.
With that, please join me in thanking our guests.